Wills in the USA. 7 mistakes that could cost your family everything. Imagine this. Someone works their whole life, pays off a mortgage, saves money, builds a retirement account, buys a car, maybe even invests a little. They believe that when they're gone, everything will automatically go to the people they love. But after they pass away, their family suddenly ends up in court. Lawyers, paperwork, legal fees, conflicts between relatives, and a process that can last months or even years. Why does this happen? Because there was no will. And this is far more common than most people think. A lot of people believe wills are only for the rich, that if you don't own multiple houses or a big business, you don't really need one. But that's not true at all. If you have a home, a car, a bank account, retirement savings, children, or even personal belongings that matter to you, a will already applies to you. Today, I'll break down how wills actually work in the United States, the most common mistakes people make, and how to make sure your family never ends up in a legal nightmare. And I'll explain everything in simple, clear language, no legal jargon. Let's get into it. Mistake 1. Thinking wills are only for the wealthy. This is the most common misconception. People say, I don't have much. I just have a normal house. There's nothing complicated here. But let's look at reality. A home worth $400,000, a car, a retirement account, savings, life insurance, personal property. For most American families, that already represents a significant estate. And if there is no will, you don't decide what happens to it. The state does. What happens without a will? Each state in the U.S. has its own inheritance laws. These laws decide who gets what and in what proportion. But the law doesn't know your personal relationships. It doesn't know who you actually consider family. For example, if you lived with a partner for 20 years without being legally married, that person may receive nothing in many states. If you wanted to leave money to a close friend, a niece, or a charity, it might never happen without a will. That's why a will is not about death. It's about control. Mistake 2. Not naming an executor. People often focus only on who gets what, but there's another critical role. Who actually handles everything after you're gone? Who pays final bills? Who closes accounts? Who deals with the court? Who distributes assets? That person is called the executor of the will. This should be someone you trust completely. A spouse, an adult child, a close relative, or a trusted friend. But here's the key point: you should always ask them first. Many people find out they were named executor only after someone has died, and it's a serious responsibility. Mistake 3. Using vague language. This is where many families end up in court. For example, I leave everything to my children. Sounds simple, right? But what does children actually mean? Biological children only? Adopted children? Stepchildren? Children from previous relationships? Without clear definitions, this becomes a legal battle. That's why attorneys always recommend being specific. Use full legal names. In some cases, even dates of birth. The more precise you are, the fewer problems your family will face later. Mistake 4. Ignoring state requirements. There is no single federal law for wills in the United States. Every state has its own rules. And this is where many wills fail. A document can look perfectly fine and still be invalid. Most states require a few key elements. You must be of legal age, usually 18 or older. You must be mentally competent, meaning you understand what you own and what you are signing. The will must be signed by you. And most states require at least 2 witnesses. These witnesses should not be beneficiaries, otherwise the will may be challenged. In some states, a notary is also strongly recommended or required. Even when it's not required, a notarized will is much easier to validate in court. Mistake 5. Forgetting about minor children. This is one of the most important issues. A will is not just about money. It's about your children. If both parents die and there is no will, the court decides who becomes the guardian. And that person may not be who you would have chosen. Even if it's a relative, it might not match your values, parenting style, or expectations. That's why naming a guardian in your will is absolutely critical. And yes, you should always discuss it with them in advance, because this is a major responsibility. Mistake 6. Relying on handwritten wills. Some people believe they can just write a will by hand and sign it. In some states, this is legally valid, but in many states, it is not. And even where it is valid, handwritten wills often create problems. Why? Because they are open to interpretation. One unclear sentence can completely change the meaning, and then the court has to decide what the person meant. that almost always leads to family disputes. So a handwritten will should only be used in emergency situations, not as a primary plan. Mistake 7. Never updating your will. Many people write a will once and never look at it again. But life changes, and your will should change with it. You should update it after divorce or remarriage, birth or adoption of a child, death of a beneficiary or executor, buying or selling major assets, significant financial changes. Even if nothing major happens, experts recommend reviewing your will every 3 to 5 years. There are 2 ways to update it. You can add a codicil, a legal amendment, or you can rewrite the entire will. In most cases, rewriting it completely is cleaner and safer. A will is not just a legal document, it's a protection plan for your family. And its purpose is not just to distribute assets but to prevent conflict. If you remember only 3 things, let it be these. Be specific, follow your state's legal requirements, and keep your will updated. If you don't have a will yet, the best time to start is now. Because this is not a document for you. It's a document for the people you leave behind. Bonus mistakes most people never think about. Know that we've covered the 7 biggest mistakes. Let's talk about a few more issues that often surprise families after someone passes away. These aren't always discussed, but they can create just as many problems. Mistake 8. Assuming a will covers everything. One of the biggest misunderstandings is believing that a will controls every asset you own. It doesn't. Some assets pass directly to a named beneficiary, regardless of what your will says. These commonly include life insurance policy, estimate accounts like 401ks and IRAs, payable on death, bank accounts, transfer on death, investment accounts. Here's an example. Imagine you divorced 10 years ago. After the divorce, you wrote a new will leaving everything to your 2 children, but you forgot to update the beneficiary on your life insurance policy. If your former spouse is still listed as the beneficiary, the insurance company may pay the money directly to them even if your will says something completely different. The will doesn't override the beneficiary designation. That's why estate planning experts always recommend reviewing your beneficiary forms every few years, especially after major life events like marriage, divorce, or the birth of a child. Mistake 9. Choosing the wrong executor. Earlier, we talked about naming an executor, but choosing the right person matters just as much as choosing someone you trust. Being an executor isn't just an honor, it's a job. The executor may need to collect financial records, work with attorneys, file paperwork with the probate court, pay debts and taxes, sell property if necessary, distribute assets fairly. This process can take many months, sometimes even longer. For example, imagine naming your oldest child simply because they're the oldest, but they live overseas, have little free time, and aren't comfortable handling financial matters. Meanwhile, another sibling lives nearby and has experience managing finances. Choosing the right executor can save your family a tremendous amount of stress. Mistake 10. Forgetting digital assets. 20 years ago, this wasn't much of an issue. Today, it's a major one. Think about everything you own online: email accounts, cloud storage, social media profiles, online banking, cryptocurrency, digital photos, subscription services, business websites. Without proper planning, your family may struggle to access these accounts. Some companies have strict privacy rules. Even close relatives may be denied access without legal authority. Imagine someone running an online business that generates income every month. If no one knows the passwords or how the business operates, that income could disappear overnight. Many attorneys now recommend keeping a secure record of important digital accounts and instructions for accessing them. Not necessarily inside the will itself, since wills eventually become public records in many states, but in a secure document your executor can locate. Mistake 11. Waiting until it's too late. Nobody likes thinking about death. It's uncomfortable, so people postpone writing a will. I'll do it next year. I'm still young. I'll get around to it after retirement. Unfortunately, life doesn't always follow our schedule. Unexpected illness, a sudden accident, an emergency. These situations happen every day. Creating a basic will usually takes far less time than people imagine. And once it's done, you gain something that's hard to put a price on: peace of mind. You know your wishes are documented, and your family won't be left guessing. A simple example: let's compare to families. Family A never writes a will. After the parents pass away, the children disagree about selling the house. One sibling wants to keep it, another wants to sell immediately. A third believes certain personal belongings were promised to them years ago. No one has written proof. Arguments begin. Lawyers become involved. Months pass. Court costs grow. Relationships suffer. Now look at family B. The parents created a clear, legally valid will. Each child understands exactly what the parents wanted. The executor follows written instructions. The process isn't completely stress-free, but everyone has a clear roadmap. Instead of arguing over what mom or dad would have wanted, they already know. That's the true value of a will. It's not only about property. It's about reducing uncertainty during one of the hardest moments in a family's life. When should you talk about a will? Many families avoid this conversation because it feels uncomfortable, but discussing it while everyone is healthy is much easier than trying to solve problems after someone has died. You don't necessarily need to reveal every financial detail, but it helps if your loved ones know that you have a will, where it's stored, who the executor is, who your attorney is, if you used one, whether you've named guardians for minor children. Those simple conversations can save enormous confusion later. Is a lawyer always necessary? This is one of the most common questions. The answer depends on your situation. For someone with a very simple estate, some states allow legally valid wills prepared without hiring an attorney. However, if you own multiple properties, have a blended family, operate a business, have significant investments, or expect potential family disagreements, professional legal advice is usually well worth the cost. An attorney can identify issues you may never think about on your own. In many cases, spending a little money today prevents much larger legal expenses for your family later. The bottom line, will isn't just another legal form. It's one of the few documents that speaks for you when you no longer can. Without it, state law decides many important questions. With it, you decide. You choose who receives your property. You choose who cares for your children. You choose who manages your estate. You make difficult decisions easier for the people you love. None of us can predict the future, but we can prepare for it. And that's really what a will is all about. Not expecting the worst. Simply making sure the people you care about are protected if the unexpected happens. If today's video encouraged you to think about creating or updating your own will, don't put it off indefinitely. Even taking the first step today is better than waiting for the perfect time. Because when it comes to protecting your family, planning ahead is one of the greatest gifts you can leave behind. Thanks for watching.